after considering the evidence admitted during the bench trial, the parties' arguments, and the applicable law, the court finds as follows. As to count 1, malice murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 2, malice murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 3, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 4, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 5, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 6, felony murder, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 7, home invasion, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 8, aggravated assault, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 9, aggravated assault, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 10, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 11, possession of firearm during commission of a felony, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 12, cruelty to children in the second degree, the court finds the defendant, Matthew Scott Lanz, guilty. As to count 13, tampering with evidence, the court finds the defendant, Matthew Scott Lanz, guilty. This 20th day of November 2025, signed and affixed with my signature, Judge Sonia N. Brown. Would you all like to take a look at the form?
No, Your Honor.
Right, Madam Clerk, if you would please enter this non-jury judgment after bench trial into the record of the court. All right, I will hear from the state of the defense regarding sentencing.
Your Honor, we have talked, I know that the state has quite a large number of people that want to speak. I think it probably would be wise to start that in the morning. So we can get through with it tomorrow.
State.
We don't have any objection to that. Thank you, Your Honor.
All right, so we will stand in recess until 10 a.m. tomorrow morning, in which time both the state and the defense will have an opportunity to present arguments and any statements from any victim impact statements or statements in mitigation on behalf of Mr. Lanz.
Thank you, Judge.
Right? We'll stand in recess until 10 a.m. tomorrow. Oh, 1 minute, please. Court is still in session. Mr. Lanz has waived his right to appear for the sentencing. I'll start by saying that this is not an easy job. And I'm not saying that because I want sympathy or empathy from anyone. I signed up to do this job. I say that because there is no joy that comes in sentencing someone to the very minimum the law says will be a life sentence. There is no joy that comes from hearing from the loved ones about the devastation that has been caused in their lives. But I made a decision that I wanted to do this job. I made a decision that I wanted to do this job and that I committed to upholding my oath, of upholding the laws and the Constitution of the state of Georgia, as well as the law and Constitution of the United States. And I take my oath very seriously. And there were 3 things that I committed to doing when I sought to get this job. That was to be of service, to serve with compassion, and to be just. And being just or justice looks very different in every case that comes before the court, whether it is a criminal case, a domestic case, or a civil case. Because it is very, very rare that anybody comes into this courtroom for something of joy. Whether it is a criminal case and there is a defendant before the court, or victims coming before the court, or if I'm making a decision in someone's divorce about custody or visitation of their children, or someone comes in, there is a business dispute in their livelihood, the way they feed their families, I have to decide that. As Mr. Casey said something when you were here in the witness stand, you said, Judge, I know you hear a lot of cases and you see a lot of cases, and I do, unfortunately. But every single case that comes before this court is important. Every single case that comes before this court deserves the court's full attention. Deserves the court's full commitment to its oath, and deserves the court's full commitment to what the court said it would do in this position. This is the community in which I live, that I chose to live. I chose to live with my family. This is a community that I love. And that's what makes this job difficult. Because what does justice look like? Every case is different. The attorneys, law enforcement, prosecution, defense. We choose to be here every day. We made this decision to do this work. It doesn't mean that it makes it easy, whether you're state or defense, in the work that we do. But we all seek to be just, to seek the truth, to take the facts and apply the laws that have been given to us with those facts, and do the best that we can do. And in doing so, and not allowing, when you're making a decision, you don't leave your human side at the door. You don't leave your human side at the door. But you have to remember that you have to look at the facts, you have to look at the law, and you have to apply it. Even when it may not be the popular thing, or the things that people want you to do, it's without fear or favor that we serve. And to be servants of the people. That's what makes this job difficult, because you have to separate the human emotion from the facts and the law that you have before you. But I swore an oath. And I swore an oath, again, to uphold the laws and the Constitution of both Georgia and the United States, and I committed to being of service, to serving with compassion, and to being just. And so in the case of the state of Georgia versus Matthew Lanz, 22-900-922, the court sentences Mr. Lanz as follows. Count 1, malice murder, life without the possibility of parole. Count 2, malice murder, life without the possibility of parole. Count 2 will run consecutive to count 1. By operation of law, counts 3, 4, 5, and 6 are vacated. Count 7, home invasion, life consecutive to count 2. Counts 8 and 9, count 8, aggravated assault merges into count 1, count 9, aggravated assault merges into count 2. Count 10, possession of firearm during commission of a felony, 5 years to serve in confinement. Count 10 runs consecutive to count 7. Count 11, possession of firearm during commission of a felony, 5 years to serve in confinement. Count 11 runs consecutive to count 10. Count 12, cruelty to children in the second degree. Count 10 years to serve in confinement. Count 12 will run consecutive to count 11. Count 13, tampering with evidence, 12 months confinement. Count 13 will run consecutive to count 12. Mr. Lanz is adjudged guilty for the above stated offenses and is sentenced for a total of 2 life without parole plus life plus 20 years plus 12 months to serve in confinement. I'll have the attorneys look at the sentencing sheet, Mr. Barry, as far as Mr. Lanz signing, are you going to sign, or will you take it back for him to sign, or will you sign and send it?
I'll sign.
Okay. I need to sign it. Clerk, the sentence sheet has been signed. Can you please file it into the records of the court? Attorney Barry, as Mr. Lanz has waived his right to be present, I am going to hear on the record review his post-conviction rights with you, and if you would please sit in your place that you will review those rights with him.
I spoke with him yesterday about that, Judge, and again this morning, so he's aware.
Okay, and for the record, the defendant has the right to seek post-judgment relief from the conviction of the crimes by either making a motion for a new trial in this court and or filing an appeal to a higher appellate court. If he wants to file a motion for a new trial or an appeal, then he will need to file a motion or notice of appeal with the clerk of Superior Court of this county within 30 days. He may want to more fully discuss this with his attorney, and if a motion for a new trial is made and the court denies it, then he will have 30 days from the filing of this order of denial in which to file with the clerk of court his notice of appeal. The defendant has a right to have an attorney represent him on the motion for a new trial and the first level of direct appellate review. And if he cannot afford to hire an attorney, the court will provide him with an attorney and a transcript of the trial at no cost. There were several felony convictions, and we'll have a period of 4 years from the date of the sentence in this court becomes final to file a habeas corpus petition. The details that can affect the time with which Mr. Lanz can file his petition are contained within code subsection OCGA section 9-14-42C. For the misdemeanor will be a period of 1 year from the date of the sentence in this court becomes final to file a habeas corpus petition. Again, the details of the time that can affect the filing of this petition are filed within OCGA sections 9-14-42C and 40-13-33. And also just explaining to ensuring that Mr. Land understands those post-conviction rights. The court will set a specified date for a hearing for the motion of the new trial once the motion has been filed and the time estimate for the preparation of the transcript has been prepared. And we will set that date and provide notice to both the state and the defense. Before we adjourn here, there's a couple of final things I want to say. First, there are other words that I can say to family and friends that are going to fill the void in your hearts, and I recognize that. There is nothing that I can do or a sentence that can replace the ache in your spirit. I don't even want to use the word closure, because there is no closing on the love that you have for Justin and Amber. But it is my hope, and my sincere hope, that you can take, even if it's just a small step, forward towards healing. That the thoughts of Justin and Amber that now bring tears to your eyes will be more memories that will bring smiles to your heart. Recognize that Jacob does not have his mom and dad. Dad isn't there to throw him his first football and teach him to swing a bat, but he has granddad who's going to show him how to do that. Or mom to show up for muffins and mom. But there are a lot of aunties and grandma and cousin aunties that will be there to do that for him. A few weeks ago, I saw a response to a post that a friend made, that someone had made about the loss of their loved one. And it stuck with me the last few weeks. And it said, "What is remembered lives." And I know that Justin and Amber are well remembered, so they will live. This court is adjourned.